Welcome back to the 22nd Annual Family Cafe and the afternoon session here on Thursday. Yeah, my voice cracked there.
I know. What happened?
Sorry about
that. All right. You've been talking a lot. We've been doing a
Too
lot
much
of talking.
Yes,
that's
this is number 24 of our 26 live sessions. So we're getting close to the end, and that's exciting.
Right. It is. It's a little sad, too.
It is. Well, this one is an important one. It has a lot of great content. It comes to us from our friends at Disability Rights Florida. And our presenter is Z. Felicia Jordan, talking about supported decision-making and guardianship alternatives. We're going to hand it off to her momentarily, but before we do, we just want to remind you, if you have any questions or comments, feel free to post them in the comment thread on the Facebook Live video, and anything we can't get to during this hour, I'm sure that the folks from Disability Rights Florida will be in that comment thread answering your questions as they come up.
Absolutely.
So please do let us know what you need to know.
Excellent. Welcome, Felicia.
Hi, good afternoon. Okay, so we're going to jump right in it. We're going to be talking about supported decision-making and guardianship alternatives today. And a little bit for your information, we're presenting our information, but it's for education and general reference and information. We're going to do our best to keep up with our law, but this is not used to replace the advice of your own legal counsel. So in other words, it's just basically stating that I'm an attorney, but I'm not your attorney, at least not yet. So you can contact us. Disability Rights Florida's mission is that we advocate, educate, investigate, and litigate to protect the advance the rights, dignity, and equal opportunities, self-determination, and choices for all people with disabilities. And our work in regards to it has been at least 40 years, and our services remain free and confidential to all our clients. So let's jump into it. So in regards to our learning objectives, we're going to kind of learn about what supported decision-making / guardianship is, what the alternatives are, who are required to provide them, and how they should help the individual with a disability accomplish. So 18th birthday, we have our balloons, our party hats, our cake, and adulthood. And it's like, what? No, really. A person in the state of Florida is considered an adult upon reaching the age of majority, meaning 18, regardless of disability, and that includes any cognitive impairment. Legally, a person is entitled to make all one's decisions once they reach the age of majority. So what can we do? As supporting our young adult, we help the child prepare for adulthood, and that's known as transition to adulthood. So we do that through education, training, employment, and community experiences. So what does transition, the process, accomplish? So we're helping our young adults transfer from with childhood to adulthood, and we help them from being dependent to being independent, both socially and financially as much as possible. This includes movement from IDEA services or Section 504 plans in educational settings to VR rehabilitation services. And we also have to look at the implications of Social Security benefits and healthcare benefits. So we have to look at all those things prior to our young person turning 18 in order to facilitate them being able to be as independent as possible. So what do these services include? Guidance, training, on-the-job experiences, a vocational training program, including college, assistive technology devices if needed, and many other services. But transition services should be individualized for that individual. There's no one size fits all in transition. And each service to be used should be based on the individual's abilities and needs. And these can be changed as their abilities and needs change. So in other words, it's once, customized to that individual. And once that is done, it always can change as that person matures and learns. So in the educational services, sometimes the things that we get a lot is, I was told that I need a guardianship to continue education services at age 18. Well, under IDEA, and yes, there's a lot of law in here, but it is also helpful if you need it as a resource. But IDEA considers an adult once that person turns 18 years old. And according to IDEA, any rights under the educational services transfer to the parents to that child upon 18 years old. The state of Florida, under the Florida Administrative Code, says that if the student with a disability has reached the age of majority and does not have the ability to provide informed consent to respect to his or her educational program, then the procedures established by statute may be used by the parent. So there are choices. So they could say that, yes, you can have the student declared incompetent and have the appropriate guardianship established according to Chapter 744, or be appointed to represent the educational interests of their student through the student's eligibility for FAPE. So that's the alternative. You don't necessarily have to get guardianship. You can also be appointed to represent the educational interests of your transition age student. Or you can have another appropriate adult appointed to represent the educational interests of that student if the parent is not available. So that going to saying that just because somebody tells you that you need a guardianship is not necessarily meaning that you have to do so. So let's look at guardianship. So what is it? So if a court finds a person does not have the ability to safely manage things that belong to them or meet their basic health or safety or self-care needs, then the court may rule that this person is what they call incapacitated. And in many cases, after the court decides that person is incapacitated, they will choose someone else to make some or all decisions for that person. And this is called guardianship. So there are different types of guardianship under the law. So there's natural guardians, there's full plenary guardians, and that could be split into guardianship of the person and guardianship of the property. We also have guardian advocacy for individuals who are receiving mental health treatment. And we also have guardian advocacy for individuals who have a developmental disability. There are also other type of guardianships, but we're going to limit this list for this presentation because we'll be here all day. So we don't want to have that. So under natural guardianship, under Chapter 744.301, subsection 1, parents jointly are the natural guardians of their own children and of their adopted children during minority unless the parents' parental rights have been terminated pursuant to Chapter 39. So in other words, as long as that child is not under a dependency case, the parents are considered the natural guardians and can make that decision on behalf of their child until they turn 18. Full guardianship. So this is when a court finds that an individual is unable to perform all the necessary tasks for their care of their person or their property, and the court finds and rules that that person is totally incapacitated. This is known as a full or plenary guardianship. This is the most restrictive type of guardianship, and few people require this type of guardianship. There's always a situation where that may occur, however, it's not always required. So what can a guardian do? So a guardian can do on behalf of a person under guardianship, they can enter into contracts, they can sue and defend lawsuits, they can apply for government benefits, they can manage the property or make gifts or dispositions of that person's property. They can determine where that person under guardianship lives. They can consent to medical or mental health treatment on behalf of that individual, and they can make decisions about their social environment or social aspects of their life. So a guardian can choose whether or not you can go on Facebook or go on Instagram or TikTok or anything like that, or can you see your friends, or can you go out to the movies or anything. So a guardian can make all of those decisions on behalf of that person under a guardianship. Some of the rights that could be taken away under Chapter 744, to marry. So if under the order letters from the judge in regards to the guardianship, if the right to enter a contract has been removed, the right to marry is subject to court approval. They can also take away your right to vote, to personally apply for government benefits, to have a driver's license, to travel, or to seek or retain employment. And that can happen whether you're trying to get a job or you're trying to get educational, vocational rehabilitation services in order to get training for a job. So that may be a situation where if you're under a guardianship and under that guardianship, that right has been taken away, you would have to petition for the court to get permission to do that. These are some legal rights that can never be taken away under guardianship. So the right to be represented by counsel always are retained by the person under guardianship. The right to access a court is always retained. The right to have a proper education is always retained. The right to be free from abuse, neglect, or exploitation, the right to receive necessary services or rehabilitation, and the right to be treated humanely with dignity and respect are always retained by the person under guardianship, no matter what. So these are some rights that basically would have to be petitioned for under court authority in order for the guardian to do this. So to commit somebody under guardianship to a facility, an institution, or a licensed service provider without having formal placement, they would need court authority. You would have to go to court in order to get permission to do that. To consent to performance on the ward for any experimental treatment, biomedical behavior procedure, or something like that has to have court approval. To initiate a dissolution of marriage for the person under the guardianship, other words, a divorce, has to be having to have court approval. To consent for the person under the guardianship to terminate their parental rights has to be done with court approval. Consent to behalf on the person under the guardianship to perform sterilization or abortion procedure has to be done with court approval. And to consent to change the person under the guardianship's residence from one county to the other in the state of Florida has to be done with court approval. And last but not least, and as we learned over the last year, one of the things that we have is also whether or not you want to have a do not resuscitate. That also has to be now under court approval. In the past, guardians were able to do that, I guess, without court approval. And now it's more codified in order to get that done. Okay, so what are the steps in the guardianship process? So we have the incapacity proceeding. So we have our petition, and then they have the examining committee. They have a court-appointed attorney. We have the hearing, and then the judge and supposed to be looking for lesser restrictive alternatives prior to initiating the guardianship. But if that judge feels that person is requiring the guardianship based on the opinions of the examining committee, then they have the appointment of guardianship. Then after that point in period of time, we have our initial guardianship report. So we have to have the initial guardianship plan and a verified inventory, and that has to be entered into the court docket and given to the judge. We also have a responsibility for an annual guardianship report. So every year, you have to have an annual plan and an annual accounting. And a lot of people think that if you do a guardianship, it's a one and done situation. No, this is an annual situation that has to be maintained every year by that guardian. So there's an annual plan and an annual accounting, sometimes a simplified annual accounting that has to be presented to the court every year on behalf of the person under the guardianship. And then we have the final report if we close it out. So guardians must pass a criminal and credit check. They must have an attorney, and they have to have a training course. Okay, guardian advocacy. So this is different. We have two different kinds on this one. So we have a guardian advocacy for individuals who receive mental health treatment, and they have an administrator of a facility may petition the court for an appointment of a guardian advocate upon an opinion of a psychiatrist that the patient is incompetent to consent to treatment. If the court finds that the patient is incompetent, meaning that they can't make that decision to consent to treatment and does not already have a guardian with the authority to consent to that treatment, then the court may appoint a guardian advocate. So the person who's appointed a guardian advocate must agree to the appointment. Now, this is different from the guardian advocacy for individuals who have developmental disabilities. And these can be placed under a person who with a developmental disability can be placed under a guardianship, under a guardian advocate, even when the court has not determined them to be incapacitated. So there are specific conditions for developmental disabilities that the court allows, and they're basically only the rights of that person, specific rights can be removed. So they have a checklist and they'll go through them one by one and not totally remove all the rights. And the court may look at the individual support plan, their individual education plan or IPE, or other supporting documents to determine the level of disability and need for assistance. So the common areas that a guardian advocate may assist with those individuals is giving informed consent to medical procedures and mental health treatment, managing money or property, applying for governmental benefits or entitlement, or deciding on residential choices. So Florida law requires that guardians and guardian advocates consider the person under the guardianship's wishes and allows that person to participate in the decision making through their lives as supposed to ideally. Furthermore, Florida law places the duty upon the guardians basically to notify the court if the guardian believes that a person under guardianship can regain capacity or if one or more rights have been removed or restored to the ward. Now, ideally, this is what we would like to see. Does it always happen? No. So, dealing with that, with guardian advocacy under developmental disability, if a person with an intellectual or developmental disability is assisted in making decisions for themselves, it happens when that individual with that intellectual or developmental disability is the decision maker, but is provided support from one or more persons to explain the issues to that individual in a manner that he or she can understand. There is no one model for support decision making, but the more information we can give them, the better. So in Florida, we have at least one court that found the supported decision making agreements was a positive, powerful alternative to guardianship. We self-advocate Michael Lincoln, with the help of Disability Rights Florida, was able to end his guardianship and enter into a supported decision-making agreement that allowed him to keep all his rights. So we have our little handy-dandy chart, and I'd like to give thanks to Fritz Fitch for helping create this. But we're looking at levels of adulting. So the most rights are given to individuals with self-determination. And then as you go down the list, it's a little less. So we have our supported decision-making with our circle of support, and we have our advanced directives. We have our living wills, our power of attorneys, our healthcare surrogates, our banking services, our trust. And then we go down to representative payee. And then with less rights are our court-imposed guardianships. So our guardian advocacy, our pre-need guardianships, our voluntary guardianships, our emergency guardianships, our limited guardianships, and our plenary full guardianships. So if you go up the little triangle, it gets more rights, but if you go down the triangle, you get less rights. Okay, self-determination. So this is a capacity of managing one's own affairs, making one's own judgment, and providing for oneself. So we're looking at believing that you can control your own destiny. And it's a combination of attitudes and abilities that lead people to set goals for themselves and to take initiative to reach those goals. And it's about being in charge. It's not necessarily the same thing as self-sufficiency or independence, but it means making your own choices and learning how to problem solve and take control and responsibility of your own life. So we practice a self-determination, meaning that, hey, yes, you have that freedom, but you're also going to have consequences of your choices as well. So yes, you get that greater control over your life. You have opportunities to make meaningful choices. You have the ability to choose from a variety of lifestyles, goals, and preferences. So we have learning activity. You guys may want to put it in the chat box, but we're looking at Anne. And she's an 18-year-old woman who is deaf with mild autism and has a seizure disorder. And she wants to move out of the family home and attend the local community college. Anne's mother thinks that Anne should move into a group home for young adults with developmental disabilities who need support services, and Anne's support coordinator agrees. Is this an example of self-determination? No. And here's the second one. So Anne is on the Agency for Persons with Disabilities waiver and also receives Social Security disability insurance. Anne's mother is her representative payee. Anne asks her parents, support coordinator, high school guidance counselor, who she remains friends, to attend a meeting to make some decisions about what she should do next and how the funding and services should be applied. Now, this could be considered a good example of supported decision-making or self-determination. So we also look at if the support coordinator gives Anne a list of group homes to choose from. Is this an example of self-determination? Then we get to the last one. Anne asks the support coordinator and her mother to help her prepare a budget and to research options for available on-campus housing. Is this an example of self-determination? So these could be performed in various ways in order to give that person freedom of choice, but yet at the same time, support them in the decisions that they're trying to make. So we look at person-centered planning. So a person who plan is effective should be the one leading the process. So in our previous example, Anne is that person. So she's the one that's supposed to be leading the planning process. The decision ultimately is made by her. We're just giving her the support she needs. Person-centered planning is the decisions driven by the person's wants, needs, and financial abilities, and is more respectful than decisions made for that person without their input. So let's look at some tools for the supported decision-making. Advanced directives. Now, with advanced directives, that requires a person to have capacity, meaning that they had not been found incapacitated by a court. So we could use living wills and we could use healthcare surrogates in regards to that type of documentation. So these can be completed without an attorney. I know, an attorney's telling you that. Can't believe it, right? So the creation of healthcare surrogate form or a living will is a great opportunity to use supported decision-making process in assisting making adults' wishes known for healthcare needs or advanced directives. And this form can provide someone to speak on their behalf in the event that they're unable to do so due to some sort of type of traumatic situation. A living will is a legal document that expresses that person's wishes regarding providing, withholding, or withdrawing life prolonging procedures in the event of a terminal condition, end-stage condition, or persistent vegetative state. This is also known as advanced directive. A proper living will allow others to know your wishes for healthcare in event if you have a terminal condition, an end-stage condition, or persistent vegetative state. And Florida Statute 765.302, subsection 1, provides for that procedure for making a living will as well as providing notice to the physician. So you can actually go on to the Florida Statutes webpage, and there's a suggested form there for you to actually copy and paste and fill out and be able to use that. So you can find that at Florida Statute 765.303, and they have a suggested form for a living will, but this will apply to adults only. So healthcare surrogate, we talked about that a little bit before, and it's a legal document that gives permission for another person known as a surrogate to receive that individual's health information and to make healthcare decisions for that individual. Healthcare surrogates also serves as preparation in the event that that person is no longer physically or mentally able to make informed healthcare decisions. The writing can provide this authority to take effect immediately or upon legal determination or of incapacity. These type of documents, I think everybody should have, not just individuals with disabilities. I think everybody should have these. These are helpful information so that your loved ones know what you want. The advantage of this is also they can be completed without an attorney. Again, I know, shocking. We also have the creation of the healthcare surrogate form. And again, let someone know what their wishes are in the event that you're unable to do so yourself. So the legal intent for the healthcare surrogate is to provide that every competent adult has a fundamental right of self-determination regarding the decisions pertaining to his or her own health, including the right to choose or refuse medical treatment, quote unquote. Also, it establishes a procedure that allows a person to plan for incapacity by executing a document or orally designating another person to direct the course of his or her health care or to receive his or her health information or both upon his or her incapacity, quote unquote. So if we look at this, I also provided a statute basically letting you know that if you have a little pushback from a healthcare facility, this is what you could be able to use in regard to letting them know what your rights are in using a healthcare surrogate form. Okay. It also has penalties that if it's not of a healthcare provider, facility shall be subject to a professional discipline or revocation of license or certification and a fine not more than $1,000 per incident or both if the healthcare provider or healthcare facility as a condition of treatment or admission requires an individual to execute or waive an advance directive. So we have little teeth put there. Where can we find these healthcare surrogate forms? Okay, Florida statute, again, you can go onto the website, Florida statute 765.203 provides a suggested designation form for healthcare surrogate for adults. And then if you look at Florida statute 7652038 provides a suggestion designation form for healthcare surrogates for minors. So you can cover both the minor and the adult, and it's easy. You can just go on to the Florida statute and they have a suggested designation form already there ready for you. Representative payees. Okay, so this is more dealing with Social Security benefits. And this is something that I'm passionate about. Actually, I'm a director for the Social Security Representative Payee Program for Disability Rights Florida. So this means that Social Security determines if an individual needs assistance in management of their Social Security benefits. And this representative payee person is required to do an annual accounting to Social Security showing how they manage that Social Security benefits on behalf of that individual. So I have a wonderful team that's all we do is go out and audit the representative payees to make sure and review their financial documents to make sure that this money is being used on behalf of the beneficiary. And they are a great set of people, and I'm excited to be working with them. Okay, power of attorney. So a power of attorney is a legal document. It gives someone else the power to act in the place of another person. This means that the person has the authority to carry out activities that they believe the other person will do for themselves. In order to have a power of attorney to be created, that individual must understand how it can be used and the effect that it has on their property. In Florida, a power of attorney must be signed before 2 witnesses and a notary to be considered a legal binding document. So, going to Office Depot and scan and it has to be signed before 2 witnesses and a notary to be considered a legal binding document. The other thing with power of attorneys, it can be customized. So you don't always have to have one that covers everything. If you want one just for the purposes of education, you can have an education power of attorney. If you want one just for healthcare beyond what the healthcare surrogate form will provide, you can have one just for that. If you have one where you want to pick out that if you become incapacitated and no longer can do things for yourself, and you're picking out who you want to become your guardian, you can do that as well. So and they also have one where you want someone just to handle your finances for you. That's another way you can do it. So that's where that customization comes in, where it's not one size fits all. You just have to look at what that transitional age adult would need. Okay, so power of attorneys. It gives the adult a legal authority to act for another person. So they call it the attorney in fact. That attorney in fact is not responsible for the actions or the debts of the principal. We have also what they call durable power of attorneys. So what happens is that once you lose capacity on a regular power of attorney, you kind of lose that power. But under a durable power of attorney, you can put in place someone else to take over in case you cannot no longer have that action under that power of attorney yourself. And if you become incapacitated, that person, if deemed by the court, can take over. And there are changes to the statute that may be coming up in regards to this particular documentation. So again, durable power of attorney. If that person becomes later incapacitated, the power of attorney can be revoked unless that individual specifically agrees that it continues after the court deems them no longer have capacity. Again, that's durable power of attorney. That's a special kind of power of attorney. It remains intact and durable, even if that person suffers mental incapacity in the future. It can deal with all financial decisions, authorize medical care, including, terminating medical or surgical procedures on your behalf. And that includes an agreement that falls under the Life Prolonging Procedure Act of Florida. So it also lets some, so that's one of the good things about that. If you want to select somebody in advance, that you don't want to select someone in advance, it can be done. Banking options. So these are various things that we can do. So you don't always have to go all the way to guardianship deal. You can basically do some things that, monitor, especially if it's just financial. Banking services can be utilized to assist that individual in managing money. You can do a joint bank account or be a co-signer on an account, and also use online banking for direct deposits. and online bill paying. So you can check and see and utilize and assist that individual who needs support in managing their finances. Depending on the bank, you can have alerts. So if they spend over a certain dollar amount, it alerts you. You can go into the online site and see what they spent the money on or what they used it on, and you can always have a discussion about it. So it's a matter of learning. Like I said, everybody doesn't always know, financial literacy off the bat, and that's something that once we learn, it's a process, and we continue to learn it throughout our lives. Trust accounts. Trust accounts can be also utilized to assist the individual with disability planning and maintaining an individual's quality of life. So we have revocable trusts and irrevocable trusts, such as special needs trusts, are examples of trusts that can maintain one's eligibility for public benefits. This one would require an attorney. So you can contact an attorney that specializes in setting up trusts to get more information on how the trust can be administered to assist protecting the best interests of an individual with a disability. This is different from an ABLE account. ABLE accounts can be used to assist that as well, but ABLE accounts also have certain guidelines, and I didn't discuss that much here, but that's one of the options you can also look into regarding planning and maintaining a person's quality of life with an individual with a disability. So with trust, the trustee holds the property and funds for the beneficiary of the trust. It could be that person's own money or given to the trust by the trustee or someone else, similar to an ABLE account. Special needs trusts are designated to prevent assets from impacting the receipt of public benefits such as SSI and Medicaid, because those are financially sensitive, and that's something that you always have to look at. Looking at medical proxies. So if a person lacks capacity or have a developmental disability and they don't have a advance directive or a doable power of attorney, or sometimes they need medical decision making, we can also look to medical proxies in regarding assisting in the supported decision making process, especially with regards to healthcare and medical decisions. I know it is clear as mud. I know, but capacity is not a fixed concept. A person's ability to make decisions may change over time. So we one point may have that capacity, and as we get older, we may lose it, or we are younger and we're learning and we become more independent and learn how to do those decision-making abilities and be able to not need as much assistance. So we're always going to look at less restrictive alternatives always as an option, and you may have to try more than one in order to try to find out what works for your loved one. Now, how we can assist. So as Disability Rights Florida, again, we advocate for the rights and needs for individuals with disabilities. So we advocate, educate, investigate, and litigate to protect and advance the rights and dignity and equal opportunities, self-determination, and choices of all people with disabilities. And like I said before, our services remain free and confidential. All you have to do is contact us. And I have the contact information at the end of my final presentation slide that you can basically contact us. We have an 800 number. We don't charge for our services. We're available. And if if there's something that we can possibly help with, we'd be more than happy to. We have a variety of services that we provide for individuals, and all you have to be as an individual with a disability. We don't have an age requirement. We don't have an income requirement. All you have to be is an individual with a disability. Shameless plug. We have our 2021 public input planning survey, and your input matters to us. So we want you to please visit our link between June 1st and August 15th to complete our annual public input planning survey. We use your responses to help us plan our goals, priorities, and objectives for the 2021 year in regards to what services we need to provide for individuals with disabilities throughout the state of Florida. We also have it in other languages. So if you prefer to use it in your native language, that's available to you as well. You can go to www.disabilityrightswithan.s, Florida, spelled full out, .org/survey. Again, that's www.disabilityrightswithan.s, Florida, spelled full out, .org/survey. Okay, this is our contact information. We can be reached. This is our main office, which is at 2473 Care Drive, Suite 200, Tallahassee, Florida, 32308. Our 800 number is 1-800-342-0823. Our DD line is 800-346-4127. And our website is www.disabilityrightswithan Florida spelled full out.org. Okay, do you have any questions?
Felicia, thank you so much. That was so helpful. And we're going to add the disability rights survey to the comment section here soon. And, I feel like it's the least we can do considering all the great work that you guys do. But it's not often you're here. We will do all of this for free because it's the right thing to do. So we appreciate that. It's the least we could do to put it in there. So please go ahead and fill out that survey. Few quick questions. Someone asked, what would happen if an adult child needs a guardian advocate but does not want one?
If an adult child needs an advocate and does not want one. Oh,
Needs
that's
a
true.
guardian advocate, yeah, but the person does not want one. What happens then?
Yeah, that's a tricky situation. I would try to look at the less restrictive. We could see maybe we can work with power of attorney. If that family member is willing to, that individual is willing to allow someone to assist them in that decision-making process with either a durable power of attorney, a support decision-making agreement, the healthcare surrogate, the living will, those things. That way, that individual still retains, their autonomy, but at the same time, get that assistance that they need in regarding making decisions.
Great, thank you. How about what happens when the payee or parent dies?
Oh, we've come across this quite a bit, and it gets tricky. What happens is typically, if the payee dies, we've had that situation where you can contact Disability Rights Florida. What we've done through our payee program is that we directly contact Social Security to let them know that that's the situation, and then have them contact the local field office, especially dealing with our current situation with the corona pandemic, in order to try to get that facilitated. Typically, traditionally, an individual would be able to go into the local field office along with that individual and let them know that they want to become the payee, or the alternative that person who is receiving benefits may be able to say, hey, I can handle this money. I want to be able to handle the money myself. And can you Social Security look at that and see whether or not you'll allow me to do so? Great.
Last question, then I kind of have one to finish it off. But okay, so this person's asking this question a little specific, but if someone seeks a guardianship advocacy, could the court grant a plenary guardianship instead?
It depends. I can't speak on behalf of a judge, and every county, have different jurisdictions and rules. And it may be a situation where, a judge may feel that a guardian advocacy may not be enough. I don't really think so, because a lot of it runs kind of parallel in regards to it. It just depends on if they do not make that 7 statutory, the development of disabilities. I mean, I think that, the advocacy would be accomplished under that same thing, but it would be the court's discretion to see if that's needed.
Gotcha. Hey, so last question. What kind of cases, I mean, what kind of cases do you find yourself usually getting involved in? I mean, what do you do the most? When are your services most often requested? What is the scenario?
If you look at Disability Rights Florida as a whole, we have a lot of different teams doing a lot of things regarding individuals with disabilities. So I'm trying to run that laundry list through my head so I can make sure I cover everybody, and hopefully I don't inadvertently miss anyone. So what happens is I'll start with AEO, since they start with A. That's the Advocacy Education Outreach Team. So what they do is they actually do a lot of different things. They do advocacy on behalf of individuals with disabilities for ADA accommodations, both home, work, transportation, things like that. They also help with what we call PAVs, which is people who have Social Security issues if they're, with Social Security, if there's a barrier to employment. They also assist with education, meaning that they assist in the IEP process, and they also assist with post-secondary. So even in college, one of the cases I had was an individual at a law school. So basically we go from, preschool all the way up regarding education services. Further, they also have our client assisted program, which is CAP, is housed with Disability Rights Florida. So any cases we have regarding vocational rehabilitation or the Division of Blind Services, we assist with advocacy and investigation and litigation with those cases in regards to vocational rehabilitation services. Hoping I'm not missing anything. We also have our systemic reform team, which they work on broader things, but they also do Medicaid hearings, Medicare hearings. They help with APD service situations. They also assist with suggestion of capacity. So under 744, if a person feels like they can, have the capacity and no longer need to be under guardianship, they could petition a court for that. And we have that service available. We also have a pilot project that we have an Equal Justice Fellow, Viviana, who assists in that process with supported decision making, that she has it in Miami-Dade County, that we also work on those services. And our investigation team, they help with rights of individuals who are in facilities. So we're looking at nursing homes, ALFs, that sort of thing. Our system reform helps with situations with APD group homes. And they also do investigations for, wrongful deaths in people in facilities, that sort of thing. We also have our public policy that assists in educating our legislators. We have, I'm trying to remember, I have everybody, I think we do. Communication, who goes in and basically try to give as much information to the public as we can. And then we also have our representative payee team, which is the team that I'm the director of. And what we do is we actually go out and review the records for the rep payee on behalf of Social Security as a contract to make sure that those benefits are being used for the beneficiary. We also assist in that process. So if there's a situation where somebody knows that something is going on, like that question that you posed to me earlier, where a representative payee passed away, we can also solicit the intervention from Social Security's regional office to, as well as their local field office, to intervene to assist in that process. So we try to do that as well as go out and do outreach as well.
Wow.
That's a lot.
That is a lot. I'm impressed. Yeah, that's
something somewhere. So yes, even more.
No,
Right.
You guys do terrific work and we appreciate it.
Yeah,
And
such an important organization for people with disabilities here in our state. And I think, when it comes back to the guardianship issue, it sounds like one of the big takeaways is that it's a lot more complicated than just, either you're independent or you're under guardianship. There's a lot of space in between those two ends. So I think if people want to know, some of the more detailed information that could help their individual situation, we certainly would encourage them to reach out to you at Disability Rights.
Thank you.
absolutely.
All right. Thanks very much, Felicia. We appreciate having you here this afternoon.
Thank you, Felicia. Thank you very much.
Thank you.
So that brings us to the close of our Thursday here and the end of the day for us in terms of live sessions. Before we sign off, there's a couple important things we need to do. Of course, Disability Rights Florida is one of our sponsors, so we want to thank them. They're joined by Career Source Florida, Sunshine Health, Able United, and of course, our friends at the Department of Education and the Division of Vocational Rehabilitation.
Yes.
And Able United, who Joe is going to share a quick message from them really quickly here.
Absolutely. So Florida's qualified ABLE program is called Able United and allows you to save tax-free without impacting eligibility for public benefits like SSI or Medicaid. Join the thousands of account holders today. Plus, when you enroll by June 30th, using promo code FAMILY75, you'll receive a $75 contribution and an exclusive prize pack.
Prize pack.
A pack
Speaking
of
of
prizes.
prizes, yes.
Yeah.
We got some prizes ourselves too. Don't forget, you have a report card and a pin card, which came in your packet when you registered. You send those back with your return address, you will get a free gift from the Family Cafe while supplies last. I will say, we
Yeah.
do have supplies.
Still,
If you come to our office and see what it looks like downstairs,
yeah, a
it's
lot of
full of supplies.
Yeah.
So please do send those in. And they're also both available in our smartphone app and now online as well. We sent out an email this morning. So if you're in our email database, you will have gotten that. And that has links to both the report card and the pink card in there. So please do take a minute and fill those out. And I guess the other thing we want to talk about is what's happening tomorrow on the last day of the Virtual Family Cafe. What do we have going on, Joe?
So at 11 o'clock, it is called To Infinity and Beyond, Organizing Your Journey by Paula Kaiser Burns from the Early Steps program. And at 2 p.m., we have Maysoon Zaid, a comedian, writer, and disability advocate, as our third and final keynote speaker.
Yes. So please do come back tomorrow. Paula in the morning. She's very entertaining. She's also our Zumba instructor at the face-to-face conference. You might know her from that as well, in addition to being an early steps expert. And then it's going to be Keynote Friday once again.
Yeah.
Maysoon, a very entertaining person.
Yeah.
You're really going to enjoy that. We're going to have a conversation with her. So please do come back for both of those sessions.